So, hi everyone, and welcome to this session today. And I'll be joined by the HR Solutions team, or some of them, who'll run through some possibilities regarding post-COVID working. So please put any questions you have in the chat box and we'll get to them. And I'll hand over to you now, Victoria and Abby.
Thank you very much, Marcia, and welcome everybody. So I'm going to begin by sharing my screen. So let's see, this works. Brilliant. So welcome everybody. So thank you for inviting us to come and talk to you today. So today's going to be a bit of a HR update and an opportunity for you to ask questions. So I'm Victoria Templeton, and I'm one of the HR knowledge managers here, and I'm joined by my colleague Abby Ashford, who's one of our HR consultants. Hiya. And so what we thought we would do today is would spend some time, first of all, just bringing you up to speed in regards to the latest with COVID. So we'll just summarize where we are in terms of the pandemic and the news that has come out this week in terms of restrictions and what that means for employers. We're going to cover off vaccinations because that's a very topical subject. So I thought that'd be quite helpful in terms of whether you can mandate vaccines, how you deal with international business travel, or even can you have a policy of no jab, no job. So that's going to be something that I'll just update you on. And in recent weeks, we've also seen case rulings come through, the first of many perhaps that are connected to COVID and pandemic. And then once we've given you the update around COVID-19, I'll move on to give you an update in regards to the right to work checks when it comes to employing the right to work checks for immigration. And then I'm going to be following up on some changes that have occurred in regards to data protection, Brexit, and the implications of that. And then towards the end, before we get to the questions, which will be the main part of it, there'll be an opportunity for me to talk you through some further information where you can get access to help and advice from us at HR Solutions. So that brings me on to then the first part, and that's to do with COVID and the update that we've seen this week. So I think for me, the thing to say is the significance of Monday is more about the shift away from the government mandating what people do to a position where they're wanting individuals and businesses to take responsibility to make their own informed decisions on how they continue to manage the virus. So we are still in that pandemic, and we still have responsibilities to take in terms of being cautious. So we are moving to a phase where we want to get everybody back to work. So the messaging around work from home if you can is no longer there, but it's encouraging everybody to be back. And for all businesses that have been closed up to now, they'll be reopening. And so the message is it's about being cautious and remaining cautious, and there will still be a requirement for workplaces to follow guidance that's going to be made available by the government to help with managing the virus and live with it, if you like, in the workplace. And of course, our own responsibilities and our legal obligations in terms of managing risks in the workplace still exist. We are still governed by our health and safety legislation. So that's going to be an important part in terms of ensuring that our risk assessments are up to date. So I think there's going to be a bit of, we'll just see how things go, especially come the 19th and how it all pans out. But in terms of restrictions, then there's no legal requirements for many of the restrictions. So the number of people that can meet indoors is going to be dropped, and equally outdoors. As I said, those remaining businesses that have been closed up to now will be able to reopen. And interestingly, when it comes to self-isolation, now this is going to be next month, but those people that have been fully vaccinated, they won't be required to self-isolate if they get alerted through the test and trace system. Of course, if they've got symptoms, they still have to self-isolate, regardless of whether they've had the vaccine or not. So that's going to be a change for us as we move forward. And also, businesses and events are going to be free to decide whether to require people to evidence their vaccination status. And I think what we're going to see now, it's going to probably be inevitable that we are going to need to see some kind of evidence that people have been fully vaccinated. You can already get your COVID certificate, if you like, on the NHS app. So I think educating the workforce is going to be key in helping to bring people back into work, helping them to understand the virus, how it transmits, and the benefit and effectiveness of the vaccines, and how workplace measures will be lifting, but as responsible employers, we still obviously have requirements, obligations to protect our workers and colleagues and visitors. So we still have that duty in terms of the risk assessment and make sure it's safe. And then we know that furlough has been around for a long time, and it was extended back in March until the end of September, and that still remains the case. The changes we're going to see now is that employers are going to be required to start contributing to the scheme. So from July, employers will be contributing 10% of the wages for the hours not worked. And then for August and September, that will increase to 20%. So now I'm going to just try and give you an update in terms of vaccinations. And clearly from that announcement, the emphasis is on vaccinations, because essentially that's what's helping us to return to some kind of normality. But there's a huge debate with it in terms of both the whether it's legal and morally right. So it's very, very complex. Is it legal and ethical to mandate employees to have the vaccine? What about those who have to travel internationally for work? And can you decline to offer a job to somebody because they haven't been vaccinated? There are many, many legal and ethical questions. So we know at the moment the government have only made it a legal requirement for those working in and for adult care homes. But for all other sectors, it's entirely a personal choice of the individual as to whether they take up the vaccine. So it is going to be challenging in terms of seeing how we can move forward with that. And hopefully, most people will be taking up the opportunity to be vaccinated when they get that opportunity. But in terms of the HR side of it and the legal framework, then you need to bear in mind the Health and Safety at Work Act, the Equality Act, and the Human Rights Act, particularly Article 8. When we think about the Equality Act, then when organisations start to apply some form of vaccination policy, then the biggest risk is around whether it's going to discriminate indirectly. So those that may have disabilities, those who may be of the younger population, although that will probably be less and less as we're getting through more and more people with the vaccination programme, or even pregnant and new mothers, or if there's religious reasons why somebody is wanting not to take the vaccine. So it's got to be, we've got to be mindful of the risks that come with discrimination. The Human Rights Act as well is relevant, particularly Article 8, because by law, there could be no interference with somebody's private life. So how can you mandate the vaccine if the government aren't mandating it? And how can you physically force somebody to be vaccinated if that's essentially what they're not wanting to choose? So there are many complex issues with regards to vaccinations. I think in terms of the legislation, there's probably, from a health and safety, probably an area that will support vaccinations, because the Health and Safety Act, Section 2, is all about the employer being obliged to reduce all workplace risks, making sure that they're at the lowest level. And so by potentially mandating vaccines or requiring it if it's necessary for undertaking the job, then that can help build that business argument for it. Then you've got Article 7, which is more about the employee and their legal responsibilities, because they are required to comply with their employers with any measures that are being put in place from a health and safety perspective. But if we think about indirect discrimination, as I touched on a moment ago, so regardless of whether you're maybe thinking no job, no jab, no job, or you know, you want all your employees to be vaccinated, then some discrimination can be lawful if even though it disproportionately affects certain groups, but there is a two-stage hurdle process, if you like, that you have to demonstrate. So if you as a business can clearly define a legitimate aim for why you're wanting to do it, so in this case, it would be about trying to lower the risk of COVID transmission and also support the wider society in tackling and combating COVID. You know, that's part of your business case and the first hurdle achieved. The hardest part, though, and where the risk is around how can you demonstrate that you can't achieve that legitimate aim through another way? And so a tribunal will look to understand whether discrimination was proportionally justified, i.e. was a method of achieving that aim proportionate, or, you know, is there no better way in which to meet that aim? Now, this hasn't been tested by the courts. And as I said at the start, we are starting to see some rulings come out. We haven't on this, but for me, if I think about if somebody's not wanting to be vaccinated and it's potentially a requirement of the role, or then could lateral flow tests be that alternative for achieving that same aim? Now, appreciate lateral flow tests aren't 100% accurate, but nevertheless, they do go some way towards picking up infections and enabling people then to start self-isolating. And if you think about it, it's, you know, less invasive. So whether that's a suitable alternative for achieving that same aim, you know, that's obviously ultimately what the court's going to be decided on the particular case. But in a nutshell, that's where your risks are in terms of the vaccination piece. So it is very complex, and you know, obviously there's a number of ethical reasons. So and those principles apply, as I say, whether you're having to think about it for existing employees or whether you're thinking about a policy of no job, no jab, no job. So just bear those in mind. And then when it comes to international business travel, you know, we're wanting to start open up and restart, you know, traveling again. Now, if that comes with the role, I would say the circumstances are perhaps slightly different, because you have to take into consideration the requirements of that the country, sorry, that they're traveling to. So if there's that country is restricting, you know, you have to be fully vaccinated to enter the country, then that is obviously significant. And what you'd want to do is obviously work with that employee to understand, you know, any concerns they may have for why or hesitancy for having the vaccine, understanding the implications on their role, whether or not any adaptations can be made. But that situation is probably slightly different to the other ones that I've talked about, simply because you've got you know, something outside of your control, another country that's demanding people be vaccinated. So they're the challenges that come with the whole vaccination piece, and we'll see how things go as we move forward, you know, with companies wanting to start opening back up again. And I touched on that we're starting to see some tribunal cases. So as on this slide here, so in the case of Mr. Kubilius versus Kent Foods, this is all about refusing to wear face masks. Now, their employer, Kent Foods, had a handbook which stipulated that they needed to demonstrate courteous behaviour with members of the public, clients, and obviously colleagues. And the handbook also talked about employees have an obligation to take all reasonable steps to safeguard health and safety of themselves and others. Bearing that in mind, this driver was asked by the third party, the client, to put a face mask on. He refused several times. The client then raised a complaint with Kent Foods to say, you know, the individual is refusing to wear the face mask. We need it. We've identified it as being PPE, you know, to protect and reduce the transmission. And what Kent Foods did was to discuss the issue with the individual. They looked at redeployment opportunities. They even went back to the client to consider whether they would think again and reconsider, but they wouldn't. And so that led them down the disciplinary process. And after all that, they ultimately ended up dismissing the individual. And in this case, the tribunal erred or found in favour of the employer, Kent Foods. The dismissal wasn't unfair. It actually was within the band of reasonable responses available to that organisation. But they did acknowledge that actually another company, another reasonable employer may have also chosen another alternative to dismissal. So that's quite interesting. Now we're getting the case rulings come through. And the second one that's come about is Mr. Rogers versus Leeds Laser Cutting. And that's again about an automatic unfair dismissal. So he didn't have the 2 years service to qualify for applying for ordinary unfair dismissal. Now, he argued that the workplace was not safe, that he was in serious and imminent danger because one of his work colleagues had to go home to self-isolate. And he refused to return to work until lockdown eased. Now, the company had undertaken its COVID risk assessment. They'd introduced COVID secure measures, but the employee claimed that it was still too dangerous for him to come to work. And he also raised the fact that he had a daughter, I believe, that had sickle cell disease. So he was trying to protect himself and his family. So he refused to carry on coming into work. Now, in the judgment, the tribunal found actually there was no more risk in the workplace than compared to general society. And, the circumstances of the walkout didn't constitute danger. They also acknowledged that the employer had taken several reasonable steps to reduce that transmission, as well as the lack of evidence from Mr. Rogers in trying to demonstrate an evidence that the workplace posed imminent and serious risk. So what we also found through those proceedings, Mr. Rogers actually conceded that the workplace may possibly have been safer than the community. And he admitted to having travelled to the local hospital. Now, during a pandemic, that's probably the last place that you want to be going to. But he admitted through his testimony that he'd made visits to the local hospital. So that case found in favour of the employer. He hadn't been automatically unfairly dismissed. It was interesting that it noted that because we don't know how he was dismissed, we don't know whether there would have been any ordinary unfair dismissal, i.e. failing of process in any way, but we know that the automatic claim of unfair dismissal didn't stand up, and he lost that case. So that's in terms of COVID, and I'm going to just move on to right to work. So we've known for some time that we've been in a transition period for moving to the points-based system, and that the right to work checks that we've always had in place have been able to carry on up until June this year. So from the 1st of July, when it comes to right to work checks, it's important to know that your checking process remains the same. So you still have a list A and a list B of acceptable documents. Irish citizens continue to have unrestricted access to work, and EU nationals will have either the pre-settled or settled status or a visa under the immigration system that gives them the entitlement to work in the UK. And that can be established through the checking process, which you can do manually or online. Now, in terms of online checks, there are certain immigration statuses that can be checked. The list has been broadened, so we now have the status issued under the EU settlement scheme and status that has been issued under the points-based immigration system. But essentially, you can undertake those online checks as we've always done. The interesting thing about this whole transition period is that the Home Office have been explicit in saying that employers who already employ EU nationals They do not have to not required to carry out retrospective right to work checks on their employees. And the reason being is because when employers carried out the right to work check when they appointed that person, that gave them the statutory excuse against any liability for illegal working, and that remains in place. So it does feel a bit unusual in that you don't know of your existing workforce who hasn't applied and what confirmation they've had back, but the government have been very clear that you actually don't need to have that retrospective check because you've already done it, and that gives you that defence moving forward. EU nationals that are waiting the outcome of their EU settlement scheme status, just so you know, can continue to live and work in the UK until its conclusion. So even though we've now hit the 1st of July milestone and we now need the checks and we've got the new systems in place, they can continue to live and work whilst they're waiting the outcome of their application. EU nationals without immigration status, though, will have 28-day notice period from the Home Office before the Home Office start taking action. And during this time, they can make a late application to the EU settlement scheme. But they must have reasonable grounds for why they missed that original deadline of the 30th of June, because we have known about it for some time. And I'll come on to what those reasonable grounds are in a moment. But also there's flexibility now for organisations who identify where there are EU nationals in their employment who haven't applied by offering a new process that will enable the individual to still apply to the scheme and do that late application, which I'll just quickly run through in terms of the key steps that employees need to be mindful of. So from when you identify that somebody hasn't obtained that EU settlement status, then you must advise that individual to make that application, and they must do so within 28 days. And for your own record keeping, you must ask that they provide you with the certificate of application. Now, on receipt of that application, you then contact the employer checking service to get confirmation that they have applied, and a positive verification notice will be provided. And a copy of that, along with the certificate of application, must be kept on your files as evidence that you've undertaken those steps and the employee has also undertaken their steps. Now, the individual may be given their immigration status before the expiry of the positive verification notice. So that PVN expires after 6 months. So you would undertake a follow-up check with the employee checking service to maintain that statutory excuse against liability for illegal working. But if they don't have that status, then the employee can get another further positive verification notice, and so another 6 months can be granted whilst their application is in the system being processed. So there is some scope for EU nationals still in this country to put a late application in. But as I said, there are certain reasons as to when an application would be considered, and there's some guidance that the Home Office have given to Home Office workers, and those reasonable grounds could be mental, physical grounds for why they didn't make that application, if they've had serious medical condition or treatment that's prevented them from doing it, if they've been a victim of modern slavery, or even been in an abusive or controlling relationship. So there are specific examples in the guidance that they will have to use to determine whether an application can be processed or not. Of course, there may be some other compelling or compassionate reasons. So it might be the individual may have not had internet access. They may have had limited English literacy, or even computer literacy skills may have been very limited. So there are certain reasons why that will enable an employee to submit a late application. So how that goes, and in terms of how many applications they get, who knows, and I'm sure we'll get further information out from them. And then just to finish off before we move to questions, I just wanted to let you know about Brexit and the implications for data. So the Brexit, the end of free movement, and since the 1st of January, there's been a massive question around, well, how can we handle, the processing and sharing of employees' data, where we are transferring and sharing it between the UK and EU countries. And the UK submitted a draft adequacy for consideration, and that got sign off by the European Commission. Initially, it was approved in draft format only back in February, but literally in the last week, the European Commission has granted it. So what that means now, and it's good news because it means that business can carry on as normal and there's not going to have to be significant changes to how we operate, but essentially it now means the UK is deemed to be protecting personal data to the same standards as those under the EU GDPR, which is great news. So for employers' point of view that share data within the EU, nothing changes. So EU member states and the EEA can continue to freely send data to the UK. Now, I don't know if many of you picked up, but at the very end of last year, it went quietly under the radar, but we had the UK GDPR brought into effect. So essentially, we have the data protection 2018, but also now we have the UK GDPR, which replaces the EU GDPR that we used to previously have to adhere to. Nothing essentially has changed. We still hold strong regard for keeping data safe and secure, and it's always been a commitment by the government to maintain those strong standards. So I think it's been really good news in the last week that we've now had that confirmation that our data within Europe can still transfer freely. So before I move on to the questions and invite Abby to come and help with those, I just wanted to give you some information. And I don't know if you are aware, but you do have access to one free 30-minute call with our HR advice line, speaking to one of our HR advisors and consultants. And you have access to our HR knowledge base. Now, our HR knowledge base provides all the templates. So you've got template letters, you've got template policies, you've got how-to guides, you've got everything on there covering everything, pre-employment, during employment, after employment. We also offer free HR risk and compliance audits. So you will also have access to ones that deal with, general HR practices, Brexit, GDPR, health and safety, and I think we also have a COVID one as well. And essentially that's a quick 5-minute tool available to you, and you get an instant report. So based on your input, your answers that you've answered, you'll get a report giving you some steering guidance as to what things we would recommend you undertake. And of course, you've got access to our monthly HR webinars and sign up to our HR news and legal email updates. So I just wanted to let you know that you've got all of that available to you. A copy of the slides will be provided after the webinar, and so there will be a link to how you can register. So if you haven't had access to these, you do need to register in the first place to get your access to the knowledge base. And also there's a link to our training courses. So we now do CPD, qualified CPD courses. I wanted just to show you a quick screen grab of our HR knowledge base. So this is essentially the home page, and what you'll see is it'll tell you at a glance all the recently new articles that have been added in the last couple of weeks, and then you'll have also the events that we've got coming up. So we actually have a new webinar program coming up where we've got them all planned out till December. And then down the right hand side, you can either search whether it's pre-employment, during employment, and then you've got your search fields along the top. So I just wanted to share with you what it looks like, the knowledge base, just as a glance while talking about it. And then this second slide is essentially showing you we've got many articles, and in fact from here you can see we've got, I think, 63 pages worth. So there is so much information out there that's available to you, so please do register, and it's free for you, so please do access it. And we always add the content At the moment, or over the last year, we've been adding lots and lots of content and reviewing it very regularly. So please do register if that's going to be of help to you. So now what I'd like to do is I'm going to hand over and invite Abby to put some questions that may have come up. So what I think I might do is stop sharing the screen and see if that's worked, and then see if we've had any questions come through.
Okay, thanks ever so much, Victoria. That was brilliant as always. Now, in terms of the chat function, if anybody wants to type a question, they can use that screen. We will all see that, and we'll go through some answers and have a discussion. So please feel welcome to do so. And whilst you're having a think about that, there have been quite a few questions, especially recently since that latest Boris Johnson announcement on Monday about lifting restrictions.
Yeah.
And our questions and answer session now isn't just, about the COVID side of things, but the right to work checks, the Brexit side, and data protection, everything that Victoria's just briefed us on. If that's, sparked a question in your mind, please feel free to add it. But meanwhile, in terms of the kind of questions that are cropping up at the moment, you might have answered part of it already, Victoria, but one that's very key is whether employers should ask their people, ask their employees if they have had the vaccination or if they plan to, if they're in the younger age bracket. I know you mentioned about adult care homes and how it's looking like that element is going to be fixed. But if it's not an adult care home setting, do we think that employers can or should ask people if they are vaccinated or plan to be?
I think it's inevitable. The way we're trying to get back to some kind of normality and reopen business, I can't see how an employer can't. And I think there will be times when it's reasonable to ask. I don't think it's a case of just a blanket approach, just asking just out of interest who is. I don't think that's the right way and wouldn't be right. But instead, for example, if I think about the changes to the self-isolation period that's coming up in August, so somebody that's got the full vaccination who gets alerted by test and trace can still go out and about their normal way. So if somebody is alerted and hasn't been double fully vaccinated, they can't come into work. So that's why I said a moment ago, it feels like it's inevitable that employers are going to have to start thinking about how they deal with what processes for getting that information. And I think there could be a reasonable argument for doing so. Clearly, we would handle that in the same way as we would handle all other medical information, keeping, adhered to the data protection, UK GDPR, and safeguarding. But it's only for what we need it for as well. We can't just, as I said like a moment ago, just ask for it. There's got to be a purpose and a reason. But I think it's going to be inevitable the way we're going.
And I also, just to butt in there, I also feel businesses have some duty of care for their staff, because there will be staff members who have double vaccinated who may not want to be in and around people who are not. And so we may need to think about bubbles for non-vaccinated days, working days, versus vaccinated days. And we won't be able to achieve that without asking. We've asked at For Communications, we've asked all our staff, we're absolutely fine with whatever they respond with, and we're just working out how that's going to work in real life. But we're thinking 3 days for vaccinated people and 2 days for non. But that's how we've been able to ask. Whether other businesses feel comfortable doing that or not is another thing.
And I think you hit the nail on the head there, because obviously we've had this announcement and it's being labelled as Freedom Day, but actually as an employer, you still have legal responsibilities to protect your workforce, and you still have to manage risks to the lowest level. So you're still having to do risk assessments. And we still are probably going to be in a world where we have our COVID risk assessments for some time, and we may recognise through that process that we still perhaps need some social distancing, even though the government are saying you don't need to have the 1 metre. So I think the next few weeks are going to be key as to how employers work out how they deal with the practical side of the messaging that's come out. But yeah,
interesting what you said there, Marcia, about the fact that you asked the question, but you also gave that message that you didn't mind either way, whether they were going to or weren't. You were just interested to know. And I think a lot of this is going to be about how it's pitched, and really disguising personal feelings on this, because you have to respect that some people are going to view this differently, and your own opinion isn't necessarily the right one. So it's the way it's pitched. I know myself and my colleagues are very concerned about this divide that is definitely there within the country, about those who are having the vaccine, those who are choosing not to for whatever that reason, whether they're just hesitant or whether it's for medical, religious reasons, pregnancy, whatever. But there is definitely that divide, and it's growing. And but fine, on Monday Boris gave the responsibility and pushed it onto employers and said, right, you do it now, and you use your common sense. But everybody has a different framework, a different common sense, different beliefs. So that is going to be the key thing now. And that does move us on to another of the questions. In fact, we've got one in the Q&A, so thank you whoever's posted that. I'll just read it out. It says, my workplace has no COVID safety measures in the work office, which I find really odd. There has also been issues with the staff feeling pressured to take the vaccine. How can we bring this up with HR? I mean, I'm going to break that question down because there's so much in that. The first bit is, my workplace has no COVID safety measures in the work office. So straight away, we've got no risk assessment going on there. Yeah, so that's the first problem for sure. And even now that things are being lifted in terms of restrictions, you've still got to have that baseline risk assessment. Just like Victoria said, if we look back before pandemic, you still had to have your risk assessments in place. You've still got that baseline duty of care, but now we've got these additional elements of ventilation, hygiene. That's not going anywhere. We all want to get back to normal, but it can't be, 19th of July, okay, we can do whatever we want now, we can do whatever we please, and we'll be fine, because we won't. So it's got to be gradual. Everything's got to be gradual, whether it's, that how many people return to the office at the same time, how many people wear masks or don't wear masks. All of it has got to be included in a risk assessment that is pertinent to that workplace and the kind of roles and the kind of industry. Do you agree, Victoria?
Absolutely. And consulting with your workforce is key, because you want people's buy-in and engagement, and to take them with you, because people are going to be nervous, and it's about trying to understand their nervousness, what's their and helping break that down and get them back into work. But I think it's interesting times, isn't it? Because like you said, Abby, it's not a matter of Freedom Day and everything goes. We are still living with the virus, significant levels, and it's how we still address it and live with it.
And if I can go to the second part of that question to make sure we cover it all. The next part, again worryingly, there has also been issues with staff feeling pressured to take the vaccine. So again, this is another bit which is this whole divide issue that I attended to. So staff feeling pressured to take the vaccine is not good. Even the original question that I started this session off with about, should we ask people if they're having the vaccine? From my point of view, if you're asking that question, or if you're pressurizing people to have a vaccine, if you then go and do something as an employer, whatever it might be, refusing a flexible working request, a disciplinary, not paying somebody a bonus, if they can attribute that to the fact that maybe this is because I'm hesitant about having a vaccine. Oh, and by the way, I'm not doing that because of religious reasons, or I'm not doing that because of to do with my health. Straight away, you've got a potential discrimination case there. So there's some real time bombs here that could, potentially be going off. So just to end off that question, how can we bring this up with HR? Well, just talking to them for sure, and not just HR. You might have a health and safety representative within your organisation. Just going through your manager, they have the duty of care for the people that report into them. So there's a number of avenues, and there is nothing wrong with asking your employer, can I see the COVID risk assessment, and could you let me know how it's been updated in preparation for the 19th of July? Even get involved,
Yeah, absolutely. Should be open and transparent, shouldn't it, the whole process?
Absolutely. Yes. Okay, hopefully we've answered that question, but it certainly brings up some of the heightened issues. I'd like to attend to something that Marcia said, and it really goes into another big area about hesitancy to return to the office. So my question that I thought we could have a talk about, Victoria, is what do we do where people say, okay, I know you've said I can come back, employer, but I don't want to. For me, the first questions are going to be, why? Because you can go down different roads. You can go down, is it because you've got to liking home working? Is it because you don't feel the premises are safe? Are you worried about public transport? What is the crux of the problem? And do some troubleshooting, basically.
Yeah, absolutely. It's sitting down, listening to what the employee has to say, isn't it? And understanding what the resistance is to then work out your action plan and try and get to the position where they are coming in. I think I can understand the hesitancy with public transport. Take that, for example, especially commute times. If you think about the underground buses, busy commute times, can you work with the individual to think about commute times around the busy periods so they're not commuting at the busy times? Or it is very difficult and very challenging because of the whole face mask, and you might be on the tube with people not wearing face masks, but you might choose you want to and do. And it's trying to find ways to try and address that particular concern. I don't know if you've got any thoughts on that piece, but I think that getting into work, I think, is going to be a barrier for a lot of people.
Yes, I think traveling, especially in London, is going to be a hiccup for a lot of people. But I also think that businesses need to think maybe a little bit differently. They've managed quite happily for nearly 18 months with staff working from home. What is the big deal if Sally from accounts says, I want to stay working from home? What is the big drama?
Yeah, that's right. I think
we've got to kind of
working is key.
Yeah, and we've got to kind of be a bit more flexible. As organisations. People have got used to being able to drop their kids off to school and pick them back up, or being able to take an hour out and walk the dog in the middle of the day, and all things like that people have enjoyed and got used to, and still made them good workers. Why would they have to travel on the tube and have to come in as demanded by the boss? Why would they? It's a question for businesses, I think.
Yeah, definitely, because before the pandemic there was so much mistrust, and I know in my line of work, whenever there was a flexible working request that came in via a client, their sort of default position was no, unless we can maybe make it work. But through building trust, through actually having everybody working from home where it was possible to do so, I appreciate that's not for every business, but it really has worked quite well in most circumstances. So I think it's about just thinking laterally, and instead of going straight away when you've got a contract of employment, so turn up, it's about thinking, right, does that person really have to start at 9 a.m? if they're willing to come in earlier and get in a quieter train, then fine. You know, surely we can accommodate that sort of thing. It doesn't have to be forever. It might just be a temporary thing with a review period or something like that. But I think really only the disciplinary side of things, just putting the HR hat on for a moment, is going to be where you've got you know, people that aren't providing a reasonable excuse for why they're saying they don't want to come into work. You know, fine, if it's to do with unsafe premises, that can be looked at. If it's to do with a request for some kind of hybrid working, fine. But if there isn't, then it does lend itself more to the disciplinary side. And I would be checking what kind of agreement people went on to begin with when they were furloughed or when they were working from home. Was it a temporary situation? And hopefully in all circumstances, that employer gave some kind of indication, hopefully in writing, to say, we need you to work from home in line with government guidance. This is temporary, so that their original contractual terms are, this is your location clause. It is at this office in London or whatever, wherever it might be. We are now lifting in line with the government guidance, and therefore you need to attend to your contract and come back to your place of work. So it can go down a disciplinary route if people aren't giving you the right information to excuse or explain why they are hesitant.
Yeah.
Okay. Let's pitch another question then. Let's have a little look. Okay, so in terms of the extremely clinically vulnerable,
Okay.
yeah, as opposed to just vulnerable people. So these are the people that would have perhaps got a letter from the NHS or something like that to say that they were extremely clinically vulnerable. How do you think we are best supporting those kind of people? Because yes, they are going to feel, or some of them may feel, a little bit hesitant about coming back.
I think there's going to be a nervousness with people who do fall in that category, and I think we mustn't forget that we still have the furlough scheme up until September, and so potentially that may be an opportunity to help deal with and address that situation. You know, it's only for a few more months. Technically, shielding no longer exists in terms of the government, and the government's message is to return to work. I think the key thing as well is going to be a risk assessment, because that still has to take place. We've always had risk assessments. So I think revisiting the risk assessment, having that conversation with the employee to understand about their health needs and the support, and try and have that conversation around thinking out the box, like you said, you know, is there some way they can continue, perhaps even temporarily, working from home, or can you utilize the furlough scheme? Last time I looked, it was still in scope. But yeah, it's just listening very carefully to their needs, and they're going to have to be reassured, because they are going to feel nervous, and that's why your risk assessment is key, and being open and transparent with the kind of measures will be there. Because like I say, the government obviously releasing the measures, lifting them, doesn't mean to say they can't still be in place. It all depends on your work environment, doesn't it, and what comes through from your risk assessment. So there will probably still be certain amount of, you know, your extra hygiene, your hand sanitizers and all of that, and they may feel they want to be wearing a face mask, you know, in the office environment if they have to be coming in. But you know, care should be given on those situations to understand their health.
Oh, and what about if you had somebody in an office environment who, perhaps because of their health condition, they come to you as their manager and say, I want everybody in my office to wear a mask? What do you think that the manager should do in that scenario?
So a company can they can have the policy that they want people to be wearing masks, or they can make it entirely voluntary for people to do it. Again, it's sitting down, talking to that individual who's asking for that request, to understand why they feel it would give that further protection, and whether it's a reasonable ask. You know, and I guess it could be something that you talk with the wider team about to get people's views, either individually or then collectively. And I think, you know, they're the things that you can be taking to just try and make sure you're taking the best approach in dealing with it.
We had something similar crop up at work, didn't we, Victoria, in terms of a query that had come in with a client where somebody in an office didn't want to be in the same office as somebody that they knew wasn't going to have the vaccine. And we were talking to them about how, you know, how well ventilated is it? What good hygiene measures have they got? Can that person perhaps move desks to be a little bit further away from that one person? But talk about eggshells. Very difficult.
I know it's going to be very difficult, which is why I think these next few weeks are going to be quite challenging to work out the logistics and the practical side of handling the message that's come out this week.
Sure. Coming towards the end of the slot, so I'll just switch to a right to work question, just so that we've covered another topic. And one that's coming up a lot is, should we not be carrying out an audit of right to work evidence for our existing EU national employees?
Technically, no. And it's hard, and I can understand why it's perhaps a recurring or common question, because it feels a little bit, what if they haven't got their status? But from a legal point of view, an employer, if they've carried out the checks as they should have done when they appointed, that's giving them the protection against any liability from, you know, if there's any audits from the Home Office that's carried out. I think where this has come from, because the government have been explicit on this and very clear, that you shouldn't require it. I mean, if an employee comes to you just to update you, oh, I've now got my settled status, Abby, then that's different, but you can't require it of somebody. And so you can't go through auditing and requesting that information. And I think it all comes back to Brexit and the fact that they were in this country while we were in the EU. They had that free movement, and it's not their fault that they're in this situation, if you like. It's the way, I guess, the UK have moved in terms of their association with the European Union. And so it shouldn't, I think this is where they're coming from, it shouldn't be made to feel that the individual is having to explain themselves. It's not through any fault of their own. I think that might be the logic why, but they are also saying you've got enough of a evidence if you've done the check in the first place.
Which is absolutely right. As a side note, I mean, EU immigration advisor to the Home Office, so that's all absolutely right. But post Windrush, where individuals were told, no, you're absolutely fine, you don't need to worry about anything, because it was all, you know, it's pre-independence, you were fine, you're welcome to stay here. I think as a business, we don't need to ask for anything from employees, but for the EU nationals who we don't need to do checks on, we should just advise them or give them the information that they might need to get themselves sorted out as individuals, not for us to do any recording or checking or anything like that, but for us to just advise them to get to sort out their affairs, to get them all straight and in order. But I mean, it's been such a big thing post Brexit that I think they've either done it or doing it, or they've gone home. Those have been sort of like, it's a bit black and white on that, but yeah, and I think, obviously we've got no business asking them to evidence anything to us, but it's just a case of being a helping hand and helping them, guiding them,
directing them to the right channels.
Absolutely,
because we're also not immigration advisors, are we? You know, we're not allowed to give advice, so but yeah.
Okay, well, that was all the questions and answers that have come up either recently or through the Q&A chat function. Marcia, is there anything else that you'd like us to discuss?
No, this is great, and thank you so much for joining us today and getting us into this or overviewing this minefield that we're just about to step on. So hopefully, when Boris makes his announcement next week for the following week, we'll be in a much better position. It'll be much clearer what businesses will and won't be doing, and hopefully the person who put the thing in the question in the chat box, their organisation will pull their socks up and get in line, because that was absolutely not right at all. So anyway, thank you so much
it's been a pleasure
for your time today, and thank you everybody for joining us.
Thank you for having us.
Thank you.
Thank you.
Goodbye everyone.
Take care.
Bye.
Bye.